What if I told you that the most important document in American history has a typo? That the founders threw a party with enough alcohol to knock out a small army? That the Constitution was kept in a closet for decades like forgotten tax paperwork? You've heard about checks and balances, the Bill of Rights, and we the people. But the real story of the Constitution is so much stranger than the version you learned in school. Over the next couple of hours, we're going to explore 99 verified facts about the US Constitution, the secrets, contradictions, and bizarre compromises that shaped everything. Not the sanitized civics lesson, the actual truth, the sweaty debates in sealed rooms, the constitutional powers nobody uses, the clauses that don't mean what you think they mean. Turn off the lights, get comfortable under your blankets, and let's talk about the document that governs 330 million people while slowly dissolving in its own ink, starting with a room full of men who nailed the windows shut in the middle of summer. 1. Written in secrecy, picture this. It's 1787, and Philadelphia is experiencing one of those suffocating summer heat waves where breathing feels like inhaling soup. Now imagine 55 men trapped inside Independence Hall with every window nailed shut. Not cracked open, nailed shut. Armed guards stood at every entrance like bouncers at history's most exclusive club. The Constitutional Convention wasn't just private, it was paranoid. The founders were so concerned about leaks that they turned the birthplace of American democracy into a pressure cooker. No press, no observers, no fresh air, just middle-aged men in wool suits, sweating through debates that would shape centuries. They feared that if the public knew what they were arguing about, slavery, state power, whether to have a king, the whole thing would collapse before it began. So they chose secrecy over transparency, which is ironic for a document that would eventually guarantee freedom of speech. And speaking of things that didn't quite go as planned, 2. Only 39 signed, so 55 delegates showed up to this sweltering secret meeting, ready to reinvent government. But when it came time to actually sign the thing, only 39 put pen to parchment. 3 delegates who were present on that final day, Elbridge Gerry, George Mason, and Edmund Randolph, flat out refused. Their reason? The Constitution lacked a Bill of Rights. No protections for speech, religion, or fair trials. Just a framework for power with no guarantees for the people. Mason had literally written Virginia's Declaration of Rights, so he knew what was missing. Gerry worried about creating a tyranny. Randolph wanted more time. They stood there in that room where everyone else was signing and said no. It takes a special kind of conviction to be the person who doesn't sign the most important document in American history while standing right next to it. Their refusal wasn't rebellion, it was principle. And it worked, sort of. 3. Benjamin Franklin's tears. Benjamin Franklin was 81 years old, which in 1787 was basically ancient. He was so frail that he couldn't walk to Independence Hall. He had to be carried in a sedan chair, like a founding father being delivered by Uberpool. When the moment came to sign, Franklin reportedly wept. Not subtle tears, full weeping. He was the oldest signer by 15 years, watching the culmination of a lifetime spent imagining what America could be. He'd helped write the Declaration of Independence, negotiated the Treaty of Paris, and now this. His body was failing, but his mind was sharp enough to know this document was imperfect. He'd spent weeks trying to hold the convention together, proposing prayers when delegates nearly walked out. And now, crying, he signed anyway. Sometimes history isn't triumphant. Sometimes it's just an old man weeping because he knows he won't live to see if any of this works. 4. The 3/5 compromise. Let's be clear, this wasn't about humanity. Nobody thought enslaved people were 60% human. The three-fifths compromise was pure political math. Southern states wanted enslaved people counted as full persons for representation purposes. More people meant more congressional seats and more power. Northern states wanted them counted as zero because counting people you've enslaved to give yourself more votes is, well, grotesque. So they split the difference. Three-fifths. For every 5 enslaved individuals, 3 would be counted toward a state's population. It gave slaveholding states more power in Congress and the Electoral College without actually granting enslaved people any rights whatsoever. It's the kind of compromise that makes you wonder what word we should use for solution when the problem is whether to count human beings as furniture or fractional political leverage. It wasn't philosophy. It was a backroom deal that embedded slavery into the structure of representation. 5. Misspelled Pennsylvania. The most important legal document in American history, the foundation of the entire United States government, has a typo. Right there on the parchment in formal calligraphy, it says Pennsylvania. One. The engrosser, a man named Jacob Shallis, had one job: copy the Constitution perfectly onto fancy animal skin. He was paid $30, and he misspelled Pennsylvania. Nobody caught it before signing. Nobody fixed it later. For over 230 years, the U.S. Constitution has gone around with a spelling error like a resume with detail-oriented spelled wrong. It's still there, preserved under bulletproof glass in the National Archives. Scholars have debated the three-fifths compromise for centuries, but the typo? The typo just sits there, silently mocking the idea of perfection. It's a reminder that even the founders, for all their brilliance, were human. Flawed. Imperfect. Apparently bad at proofreading. 6. No requirement to be a lawyer. You'd think becoming president of the United States would require some qualifications. A law degree, maybe. Political science background. Some kind of credential proving you understand governance. Nope. The Constitution has exactly 0 educational requirements. No college, no high school diploma, no professional experience of any kind. You just need to be 35 years old, a natural-born citizen, and a resident for 14 years. That's it. You could have spent your entire adult life as a professional juggler, and constitutionally, you'd be qualified. The founders didn't care about resumes. They assumed, perhaps optimistically, that voters would be smart enough not to elect someone wildly unqualified. They built in age and citizenship requirements to ensure some life experience and loyalty to the country. But beyond that, the door is wide open. It's democracy in its purest, most terrifying form. Anyone can run, and occasionally, anyone does. 7. The word democracy never appears. Here's something that trips people up. The Constitution never uses the word democracy. Not once. The founders deliberately created a republic, not a direct democracy. They didn't want mob rule or majority tyranny. James Madison, in Federalist No. 10, openly argued against direct democracy, calling it vulnerable to factions and passions. Instead, they built layers of insulation, representatives instead of direct votes, an electoral college instead of popular vote, senators chosen by state legislatures instead of the people. The word republic appears in Article 4, guaranteeing every state a republican form of government. But democracy? Nowhere. This wasn't an accident. It was a philosophical choice. The founders trusted structured, filtered, representative government more than they trusted you. And that distrust is baked into the Constitution's DNA. It's a document designed to slow democracy down, not speed it up. 8. Written on parchment. The Constitution isn't written on paper. It's written on parchment, actual animal skin. Specifically, calfskin or sheepskin that was scraped, stretched, dried, and treated until it became a writing surface. This is why the document has survived for over 230 years, while regular paper from that era has crumbled into dust. Parchment is incredibly durable, resistant to decay, and has a lifespan measured in centuries if stored properly. Of course, properly is doing a lot of work there. For its first 100 years, the Constitution was stored in various government offices, sometimes in literal closets, exposed to light and humidity and the kind of neglect you'd give to an old receipt. It's a miracle it survived at all. In 1952, the National Archives finally sealed it in a helium-filled case with UV-filtered glass. Even so, the ink has faded so much that parts are now barely visible. 9. James Madison's notes. James Madison sat through every single session of the Constitutional Convention, taking detailed, meticulous notes. He recorded debates, arguments, compromises, and tantrums. He captured what the founders actually said, not the sanitized version. And then he locked those notes away and didn't publish them until after his death in 1836, nearly 50 years later. Why? Because he knew if people read what was actually debated, it might undermine the Constitution's authority. The messiness, the ugliness, the fact that some founders wanted a king, others wanted near anarchy, and most were just making it up as they went. Madison's notes are the primary historical record of the convention. Without them, we'd have almost no idea what happened in that room. But he made us wait half a century to read them, ensuring that the founders were safely dead before their arguments became public. 10. George Washington barely spoke. George Washington presided over the entire Constitutional Convention. He sat at the front of the room for months, radiating authority just by existing. And he spoke exactly once during the debates. Once, on the final day, about a minor procedural change regarding congressional representation. That's it. Washington wasn't there to argue or grandstand. He was there to lend legitimacy. His presence alone kept the convention from collapsing. If Washington thought this was worth his time, then maybe it was worth everyone's time. He was the closest thing America had to a unifying figure, and he used that power by mostly staying silent. It's a fascinating leadership strategy. Show up, be respected, let others do the talking, then sign your name and make it official. He spoke once in 4 months, and somehow that was enough. But not everyone was so restrained. 11. Alexander Hamilton's 6-hour speech. Alexander Hamilton gave a 6-hour speech at the Constitutional Convention. 6 hours. He proposed that presidents and senators serve for life during good behavior, essentially creating an elected monarchy. He wanted the president to have absolute veto power over Congress. He wanted to abolish state governments entirely. Nobody supported him. Not one delegate. It was so extreme that even his allies pretended it didn't happen. And yet, Hamilton didn't storm out. He stayed. He signed the Constitution even though it reflected none of his vision. And then he spent the next year co-writing the Federalist Papers, brilliantly defending a document he thought was too weak. That's the thing about Hamilton. He could talk for 6 hours, lose completely, and still convince half the country to go along with the compromise. His speech was a failure. His sales pitch afterward was a masterpiece. 12. The Commerce Clause loophole. Article 1, Section 8 gives Congress the power to regulate interstate commerce. That's it. Just commerce between states. And from that single clause, Congress has justified civil rights laws, environmental regulations, drug laws, healthcare mandates, and basically any policy that involves anything crossing state lines or affecting the economy in any remote way. It's the most stretched, interpreted, and abused clause in the entire Constitution. The founders probably imagined it applying to tariffs and trade disputes. Instead, It became the legal justification for the federal government to regulate nearly everything. Courts have ruled that growing wheat on your own farm for your own use affects interstate commerce because it reduces demand for purchased wheat. The Commerce Clause has been used to expand federal powers so far beyond its original scope that it's unrecognizable, and it's still going. 13. No mention of God. The Constitution contains 0 references to God, not one. No mention of Christianity, the Bible, divine providence, or religion at all, except in Article 6, which explicitly bans religious tests for public office. This was deliberate, controversial, and absolutely intentional. Many states had official religions. Some required office holders to swear Christian oaths. The founders could have included religious language. They chose not to. Benjamin Franklin proposed opening convention sessions with prayer. The motion failed. The Constitution was designed to be a secular document governing a pluralistic society. It doesn't declare America a Christian nation. It doesn't invoke divine authority. It starts with "we the people," not "in God we trust." That phrase wouldn't appear on currency until the 1860s. The founders built a wall between church and state, and they did it on purpose. 14. The preamble has no legal force. "We the people" is the most famous phrase in American law. It's iconic, inspirational, taught to every schoolchild, and it has absolutely 0 legal authority. Courts have consistently ruled that the preamble grants no powers, protects no rights, and cannot be used as the basis for any lawsuit. It's purely introductory. A mission statement. The actual enforceable Constitution starts with Article 1. Everything before that is just vibes. The preamble tells you why the Constitution exists: to form a more perfect union, establish justice, ensure domestic tranquility, but it doesn't actually do any of those things. That's what the articles and amendments are for. The preamble is the constitutional equivalent of a book's dedication page. Nice to read, emotionally resonant, legally meaningless, but it sounds great, which is why we remember it while forgetting most of Article 3. 15. The Electoral College Compromise. The Electoral College exists because the Constitutional Convention couldn't agree on how to choose a president. Some delegates wanted Congress to pick the president. Clean, simple, no public involvement. Others wanted a national popular vote, which was radical and terrifying to people who didn't trust the public. So they compromised by creating the Electoral College, a system where states choose electors who then choose the president. It's indirect democracy wrapped in a procedural safety net. Nobody loved it. It was a last-minute deal cobbled together when every other option had failed. And we've been stuck with it ever since, watching presidents lose the popular vote but win the election because of 18th century math. The founders didn't design the Electoral College because they thought it was brilliant. They designed it because they were exhausted, and it was the only thing that didn't make anyone angry enough to walk out. 16. Original Bill of Rights had 12 amendments. When Congress proposed the Bill of Rights, they didn't propose 10 amendments. They proposed 12. 10 were ratified in 1791 and became the Bill of Rights we know. 2 failed. 1 dealt with the size of congressional districts. It's still technically pending, though functionally forgotten. The other dealt with congressional pay raises, preventing Congress from voting, themselves raises that take effect immediately. That one failed in 1791. Then 203 years later, in 1992, a college student named Gregory Watson discovered it had no ratification deadline. He launched a one-man campaign to get states to ratify it. And it worked. In 1992, it became the 27th Amendment, 2 centuries late, which means the Bill of Rights technically has 12 amendments. We just didn't ratify the last one until most of us were alive. 17. The 27th Amendment's bizarre history. In 1982, Gregory Watson was a sophomore at the University of Texas, writing a paper on the Equal Rights Amendment. While researching, he stumbled across a proposed amendment from 1789 about congressional pay raises. It had been sent to the states but never ratified. It also had no deadline. Watson argued in his paper that it could still be ratified. His professor gave him a C, saying the idea was unrealistic. Watson decided to prove her wrong. He launched a 10-year lobbying campaign, writing letters to state legislatures across the country. One by one, states ratified it. In 1992, Michigan became the 38th state to ratify, meeting the 3/4 threshold. The amendment became law, 203 years after it was proposed. Watson got his C changed to an A, and the Constitution gained its most delayed amendment in history. 18. The Constitution doesn't guarantee the right to vote. Here's a shock. The Constitution does not contain an affirmative right to vote. Nowhere does it say, citizens have the right to vote. Instead, it only says you can't be denied the vote based on certain things. Race, 15th Amendment. Sex, 19th Amendment. Age over 18, 26th Amendment. Or failure to pay a poll tax, 24th Amendment. But there's no blanket right. States still control voting rules. They decide registration requirements, felon disenfranchisement, voter ID laws, and polling hours. The Constitution doesn't guarantee your access to a ballot. It just prohibits specific forms of discrimination. This isn't a loophole, it's by design. The founders left voting rules to the states, and we've been fighting about it ever since. Democracy's foundation, the right to vote, exists primarily as a patchwork of restrictions on what states can't do, not a guarantee of what citizens can. 19. Senators weren't originally elected until the 17th Amendment. In 1913, U.S. senators weren't elected by voters. State legislatures chose them. The founders didn't trust the general public to pick senators wisely. The House was supposed to represent the people. The Senate was supposed to represent the states themselves, chosen by the state governments. This led to exactly the kind of corruption you'd expect. Backroom deals, bribery, legislative gridlock when state legislatures couldn't agree. Some Senate seats sat empty for years. By the early 1900s, the pressure for reform was overwhelming. The 17th Amendment finally gave the people the right to elect their own senators. It took 124 years for Americans to gain the power to choose half of Congress. Democracy is slow, and the founders designed it that way. But eventually, the people won this one. 20. Presidential succession was vague. When William Henry Harrison died in office in 1841, nobody knew what happened next. The Constitution said the vice president would take over the powers and duties of the presidency, but did that mean he became president or just acted as president temporarily? It was genuinely unclear. John Tyler, the vice president, decided to settle it by simply declaring himself president. Not acting president. President. He took the oath of office, moved into the White House, and refused to respond to mail addressed to acting President Tyler. Congress was furious. They called him His Accidency. But Tyler didn't budge. He established the precedent that the VP doesn't just fill in, they become the actual president. It wasn't resolved by constitutional amendment until the 25th Amendment in 1967, which finally clarified the whole process. Tyler just made it up. And it stuck. 21. No Supreme Court size specified. The Constitution never says how many justices should sit on the Supreme Court. Not even a hint. Congress has changed the number 7 times throughout history. It's been as few as 5 justices and as many as 10. The Judiciary Act of 1789 set it at 6. It grew to 7, then 9, then 10. during the Civil War so Lincoln could pack it with anti slavery justices. Then it dropped back to 7 to prevent Andrew Johnson from making appointments. Then back to 9 in 1869, where it's stayed ever since. But that's just tradition, not law. Congress could vote tomorrow to make it 15 or 50 or 3. The size of the nation's highest court, the final arbiter of constitutional meaning, is decided by simple legislation, not constitutional mandate. It's one of those structural details the founders just didn't nail down, assuming future generations would figure it out responsibly. 22. The Fugitive Slave Clause. Article 4, Section 2, contained one of the Constitution's ugliest provisions, the Fugitive Slave Clause. It required that enslaved people who escaped to free states be returned to their enslavers. And freedom wasn't determined by where you stood. It was determined by who claimed to own you. If you made it to Pennsylvania or Massachusetts, you weren't free. You were just a fugitive. Federal law enforced this through the Fugitive Slave Acts of 1793 and 1850, which deputized citizens to help capture escapees and penalized anyone who aided them. It turned the entire country into a hunting ground. The clause remained in effect until the 13th Amendment abolished slavery in 1865. For 78 years, the Constitution actively required free states to participate in slavery. It wasn't a bug, it was a feature written in to ensure Southern states would ratify. 23. Gouverneur Morris wrote most of it. James Madison gets called the father of the Constitution, and he deserves credit for the ideas. But Gouverneur Morris actually wrote the final draft, including the preamble. He took the convention's messy resolutions and turned them into elegant legal prose. "We the people" was his phrasing. Morris was also one of the convention's more colorful characters. He had a wooden leg, lost the original in a carriage accident, and was known as a charming, witty conversationalist with a reputation for pursuing women with the same energy he pursued constitutional reform. He spoke more times during the convention than anyone else, advocating passionately against slavery despite representing a state that allowed it. Morris shaped the Constitution's language, giving it the clarity and rhythm that made it quotable. Madison provided the skeleton. Morris provided the voice. 24. The convention almost collapsed. By late June 1787, the Constitutional Convention was falling apart. Small states and large states were deadlocked over representation. Delaware threatened to walk out. Delegates were screaming at each other. The whole project was on the verge of collapse. Benjamin Franklin, sensing disaster, proposed that sessions begin with prayer to invite divine guidance and calm tempers. It was a reasonable suggestion from the oldest, most respected man in the room. The motion failed. They didn't even vote on it, they just moved on. Apparently, the founders trusted their own arguments more than they trusted God's intervention. Days later, the Great Compromise saved everything by giving states equal representation in the Senate and population-based representation in the House. But for a few days there, American democracy almost ended before it began because nobody could agree and nobody wanted to pray about it. 25. The Great Compromise. The Great Compromise is why Wyoming, with 580,000 people, has the same Senate power as California, with 39 million. It was the deal that saved the convention. Large states wanted representation based on population. More people, more votes. Small states wanted equal representation. One state, one vote. Neither side would budge. Roger Sherman of Connecticut proposed a compromise, a bicameral legislature with the House based on population, and the Senate giving every state 2 senators regardless of size. It was elegant, pragmatic, and nobody really loved it. But it worked. It balanced regional power, prevented large states from dominating, and gave small states a reason to stay. It also created a system where a minority of Americans can control the Senate, which has sparked debate for 230 years. The Great Compromise wasn't great because it was perfect. It was great because it was just barely acceptable enough to prevent the whole thing from falling apart. We're 25 facts into the Constitution's real story, and we haven't even gotten to the amendments yet. If your eyes are getting heavy, good. That means the history is working. Get comfortable. There's plenty more ahead. 26. Amendments are nearly impossible. The Constitution can be amended, but the bar is absurdly high. You need 2/3 of both the House and Senate to propose an amendment, then 3/4 of state legislatures to ratify it. That's 67 senators, 290 House members, and 38 states all agreeing on the exact same thing. Since 1789, over 11,000 amendments have been proposed. Only 27 have passed. That's a 0.24% success rate. The founders made it deliberately hard because they didn't want the Constitution changed on a whim. But the result is a document that's nearly frozen in time, unable to adapt to modern challenges without extraordinary consensus. Some amendments took decades. Some took centuries. The Equal Rights Amendment has been pending since 1972. Amending the Constitution isn't difficult. It's nearly impossible by design. 27. The Constitution is short. At 4,543 words, the U.S. Constitution is the shortest written national constitution in the world. India's constitution has over 146,000 words. Brazil's has 64,000. Even Luxembourg's has more. The American Constitution is lean, vague, and open to interpretation. The founders didn't write an instruction manual, they wrote a framework. Article 1 establishes Congress in about 2,000 words. Article 2 covers the presidency in roughly 1,000. Article 3 handles the entire judicial branch in 377 words. Compare that to most state constitutions, which run tens of thousands of words and include things like property tax exemptions for beekeepers. The federal constitution's brevity is both its strength and its weakness. It's flexible enough to survive centuries, but vague enough to spark endless legal battles. Short doesn't mean simple. It just means there's a lot left unsaid. 28. No political parties. The Constitution never mentions political parties. Not once. The founders didn't want them. George Washington's farewell address explicitly warned against the baneful effects of the spirit of party, calling it the worst enemy of democratic government. He thought parties would divide the nation, prioritize faction over country, and turn governance into tribalism. He was right, of course. Parties formed almost immediately. Federalists versus Democratic Republicans, then Whigs and Democrats, then Republicans and Democrats. The two-party system became so entrenched that most Americans can't imagine politics without it. But it's not in the Constitution. It's not part of the design. It's an accident of human nature, the tendency to form teams and fight. The founders built a government without parties, and within a decade, parties took over anyway. Washington warned us. We didn't listen. 29. The president's salary. The Constitution requires the president to be paid, but doesn't specify how much. Article 2, Section 1 says the president shall, at stated times, receive for his services a compensation. That's it. The first salary set by Congress in 1789 was $25,000 per year, a fortune at the time. It's currently $400,000 set in 2001. George Washington initially declined his salary, insisting he'd serve for free out of patriotic duty. Congress persuaded him to accept it, arguing that if only wealthy men could afford to be president, it would create an aristocracy. Washington relented. Sobre Unius, the salary provision ensures that people without independent wealth can serve. It's a small detail with big implications. Leadership shouldn't be limited to the rich, though in practice, most presidents have been wealthy anyway. 30. Treason is the only crime defined. Treason is the only crime specifically defined in the Constitution. Article 3, Section 3 says, treason is levying war against the United States or giving aid and comfort to its enemies, and it requires either two witnesses to the same overt act or a confession in open court. The founders were obsessed with this because, in England, treason charges were thrown around constantly to silence political enemies. Criticize the king? Treason? Support the wrong faction? Treason. The founders wanted to make sure treason couldn't be weaponized the same way in America. So they defined it narrowly and made it nearly impossible to prove. You can't be convicted of treason for speech, thoughts, or political disagreement. It requires action, evidence, and witnesses. It's the Constitution's way of saying, we've seen how this gets abused, and we're not doing that here. 31. The Necessary and Proper Clause, Article 1, gives Congress the power to make all laws necessary and proper for executing its constitutional powers. Anti-Federalists immediately nicknamed it the Elastic Clause because it could be stretched to justify almost anything. And they were right. Congress has used it to create a national bank, build highways, regulate the internet, and establish federal agencies nowhere mentioned in the Constitution. The debate over necessary and proper has raged for 2 centuries. Does necessary mean absolutely required, or does it mean convenient and useful? Does proper impose limits, or is it just a synonym for constitutional? The Supreme Court sided with the broad interpretation in McCulloch v. Maryland in 1819, ruling that Congress has implied powers beyond what's explicitly listed. The Elastic Clause turned the Constitution from a limiting document into an enabling one. It's why the federal government does most of what it does. 32. No right to privacy. The word privacy appears nowhere in the Constitution. 0 times. And yet the Supreme Court has ruled that Americans have a constitutional right to privacy. Where did it come from? In Griswold versus Connecticut in 1965, the court said the right to privacy exists in the penumbras and emanations of other amendments. Essentially, the shadows cast by the First, Third, Fourth, Fifth, and Ninth Amendments create an implied right to privacy. It's constitutional law's version of reading between the lines. Critics argue the court invented a right that doesn't exist. Supporters argue it's obviously implied. Either way, some of the most important privacy rights in America, contraception, medical decisions, personal autonomy, rest on a word that never appears in the document. The founders didn't write about privacy. The court found it anyway, hiding in the margins. 33. The Constitution was ratified by just 1,648 people. The Constitution was ratified by state conventions, not popular vote. Those conventions involved roughly 1,648 delegates, total across 13 states, out of a population of nearly 4 million people. So the consent of the governed was given by approximately 0.04% of the population. And it gets worse. Only property-owning white men could vote for those delegates in most states. Women, enslaved people, indigenous people, and men without property had no say. The Constitution's legitimacy rests on a tiny fraction of the population agreeing to it on behalf of everyone else. The founders talked endlessly about popular sovereignty and government by consent. Then they built a ratification process that excluded almost everyone. It's not hypocrisy, exactly. It's just 18th century democracy, where the people meant a very specific subset of people. 34. Rhode Island boycotted the convention. Rhode Island didn't just skip the Constitutional Convention, it actively boycotted it. The state refused to send delegates, viewing the whole thing as a power grab by nationalist elites. Rhode Islanders liked their independence and didn't want a strong federal government telling them what to do. When the Constitution was sent to states for ratification, Rhode Island rejected it. Twice. It became the last state to ratify, and only did so in 1790 after the new federal government threatened to treat it as a foreign nation and impose tariffs on its trade. Rhode Island caved under economic pressure, ratifying by a vote of 34 to 32, the narrowest margin of any state. Even then, half the state wanted no part of the Union. Rhode Island joined America kicking and screaming, which feels very on brand for a state that calls itself the Ocean State, despite having one coastline, 35. Patrick Henry smelled a rat. Patrick Henry, the man who famously declared, "Give me liberty or give me death," refused to attend the Constitutional Convention. When asked why, he said he smelled a rat in Philadelphia, tending toward the monarchy. He suspected the convention was going to scrap the Articles of Confederation and create a centralized government that resembled the British system they'd just fought a war to escape. He was absolutely right. The convention exceeded its mandate, threw out the Articles, and wrote a new government from scratch. Henry became one of the Constitution's most vocal opponents, arguing it concentrated too much power in the federal government and threatened individual liberty. He fought ratification in Virginia, nearly succeeded in blocking it, and only relented when promised a Bill of Rights. Patrick Henry smelled a rat, and the rat was real. He just couldn't stop it. 36. The original had no Bill of Rights. The Constitution signed in September 1787 had no Bill of Rights. None. No freedom of speech, religion, or press. No right to trial by jury. No protection against unreasonable searches. Federalists argued these protections were unnecessary because the Constitution only granted limited powers, while list rights the government couldn't violate if the government had no power to violate them in the first place. Anti-Federalists weren't buying it. They refused to ratify without explicit protections. Several states ratified conditionally, demanding amendments. It became a political deal. Federalists got their Constitution, and Anti-Federalists got their Bill of Rights. James Madison, who initially opposed a Bill of Rights, ended up drafting it to fulfill the promise. The first 10 amendments were ratified in 1791. The Constitution we revere didn't include basic freedoms until 3 years after it was written. 37. The Second Amendment's comma controversy, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Lawyers and judges have spent 230 years arguing about those commas. Is the right to bear arms tied to militia service, or is it an individual right independent of militias? Does the first clause limit the second, or is it just explanatory context? The Supreme Court didn't definitively rule on this until District of Columbia versus Heller in 2008, which held that the Second Amendment protects an individual right to own firearms unconnected to militia service. But the debate continues. Some scholars argue the commas prove the right is conditional. Others argue the grammar clearly separates the clauses. It's a constitutional argument that hinges on punctuation. The founders probably didn't expect centuries of litigation over where they put their commas. But here we are. 38. The Third Amendment is almost never used. The Third Amendment says the government can't force you to house soldiers in your home during peacetime without your consent. It was a direct response to British soldiers being quartered in colonists' homes before the Revolution. And since 1791, it has been the subject of exactly one substantive federal court case. One. In over 230 years. It's the least litigated amendment in the Constitution. Nobody violates it because the government stopped quartering soldiers in private homes centuries ago. It's a constitutional protection against a problem that no longer exists. The Third Amendment just sits there quietly doing nothing, like that one kitchen gadget you've never used but can't throw away. It's constitutional history frozen in amber, a reminder of 18th century grievances that have zero relevance today. But it's still there, just in case. 39. The Constitution allows slavery without saying slavery. The words slave and slavery never appear in the original Constitution. The founders used euphemisms instead. Enslaved people are called other persons in the 3/5 clause. The Fugitive Slave Clause refers to person held to service or labor. The slave trade is called importation of such persons. It's linguistic gymnastics designed to avoid writing the word while protecting the institution. Some founders were ashamed enough of slavery to not want it named explicitly, but not ashamed enough to actually ban it. The word slavery first appears in the 13th Amendment in 1865, the amendment that abolished it. For 78 years, the Constitution protected slavery without having the courage to call it what it was. It's the document's original sin, hidden in plain sight behind careful phrasing and deliberate omissions. 40. Impeachment doesn't mean removal. The Constitution separates impeachment from removal, and most people don't understand the difference. Impeachment is a formal charge brought by the House of Representatives. It's like an indictment. Removal is the conviction and punishment handled by the Senate after a trial. You can be impeached and not removed. 3 presidents have been impeached: Andrew Johnson, Bill Clinton, and Donald Trump twice. None were removed by the Senate. Richard Nixon resigned before the House could vote on impeachment. Impeachment is relatively easy, just a simple majority in the House. Removal requires 2/3 of the Senate, which is nearly impossible in a partisan environment. The founders separated these powers to prevent impulsive removals while still holding presidents accountable. In practice, it means impeachment has become a political statement more than a functional check on power. The process works. The outcomes rarely do. 41. The vice president's only job, the Constitution gives the vice president exactly one meaningful responsibility: presiding over the Senate and casting tie-breaking votes. That's it. No executive authority. No real power. Just sitting in a chair waiting for a tie that might never happen. John Adams, the first vice president, called it the most insignificant office that ever the invention of man contrived, or his imagination conceived. He wasn't wrong. The VP has no constitutional role in the executive branch beyond waiting for the president to die or become incapacitated. Modern vice presidents have taken on advisory roles and special projects, but that's all by presidential invitation, not constitutional mandate. The office exists primarily as an insurance policy, a backup president sitting on the shelf. Some VPs have cast dozens of tie-breaking votes and shaped history. Others have sat quietly for 4 of 8 years doing essentially nothing. It's a job that's simultaneously a heartbeat away from ultimate power and constitutionally irrelevant. 42. No term limits. Originally, the vice presidency was designed to be powerless. The presidency, on the other hand, was designed with almost no limits at all. The original Constitution placed no limits on how many terms a president could serve. George Washington set the 2-term tradition by voluntarily stepping down after 8 years, and every president followed it until Franklin Delano Roosevelt. FDR was elected 4 times, serving from 1933 until his death in 1945. By the time he died in office, he'd been president for over 12 years, leading the country through the Great Depression and most of World War II. The fact that one person could accumulate that much power for that long scared both parties. In 1951, the 22nd Amendment was ratified, limiting presidents to 2 terms. It was a direct response to FDR's unprecedented tenure. The amendment doesn't apply to any other office. Senators and representatives can serve unlimited terms. Only the presidency is restricted. Washington's voluntary restraint became mandatory law because one president stayed too long. The founders trusted tradition. History proved tradition wasn't enough. 43. The Constitution can be suspended. Article 1, Section 9 includes a terrifying provision. Congress can suspend habeas corpus, the right to challenge your imprisonment in court, during times of rebellion or invasion when public safety requires it. Habeas corpus is one of the oldest protections in Western law, preventing the government from jailing you indefinitely without charges, and the Constitution allows it to be suspended. Abraham Lincoln did exactly that during the Civil War, jailing thousands of suspected Confederate sympathizers without trial. The Supreme Court later ruled he'd overstepped by acting without congressional authorization. Lincoln ignored the ruling. Congress eventually ratified his actions retroactively, which raised its own uncomfortable questions. Habeas corpus was suspended again in parts of South Carolina during Reconstruction, and in Hawaii after Pearl Harbor. The founders included this escape hatch because they knew sometimes survival requires sacrificing liberty. They just didn't specify who decides when that moment arrives. And as Lincoln demonstrated, presidents will sometimes decide for themselves. 44. Executive orders aren't in the Constitution. Executive orders are not mentioned anywhere in the Constitution. Not once. And yet presidents have issued over 14,000 of them, starting with George Washington. They're based on the vague executive power granted in Article 2, which says the president shall take care that the laws be faithfully executed. From that one clause, presidents have claimed the authority to issue legally binding directives without congressional approval. Executive orders have desegregated the military, created national parks, interned Japanese Americans, established agencies, and reversed decades of policy with the stroke of a pen. Their constitutional basis is still debated. Some scholars argue they're implied executive powers. Others call them an unconstitutional overreach. But they keep happening because Congress has never seriously challenged the practice, and the Supreme Court has generally allowed them. Executive orders exist in a constitutional gray zone, powerful, widely used, and nowhere to be found in the actual document. It's governance by implication, and it's been going on since the beginning. 45. The Ninth Amendment's mystery. The Ninth Amendment is one of the strangest parts of the Bill of Rights. It says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Translation: just because we listed some rights doesn't mean those are the only rights you have. It's an admission that the founders couldn't list every possible human right. So they included a catch-all acknowledging that people have additional, unenumerated rights. But what are those rights? Nobody knows. Nobody agrees. The Ninth Amendment has been cited in cases involving privacy, bodily autonomy, travel, and family decisions, but there's no consensus on what it actually protects. Some judges treat it as a broad protection for individual liberty. Others dismiss it as legally meaningless. It's a constitutional IOU, a promise that you have more rights than what's written down, without specifying what those rights are or how to enforce them. The Ninth Amendment is the Constitution admitting it's incomplete while offering no guidance on how to fill the gaps. 46. The 18th Amendment is the only one repealed prohibition. The 18th Amendment, ratified in 1919, banned the manufacture, sale, and transportation of alcohol nationwide. It was a sweeping moral reform supported by temperance movements, convinced that alcohol was destroying American society. It was also a disaster. Prohibition sparked the rise of organized crime, illegal speakeasies, bootlegging empires, and widespread disrespect for the law. By the early 1930s, it was clear the experiment had failed. In 1933, the 21st Amendment repealed the 18th, making it the only constitutional amendment ever fully repealed. The Constitution admitted a mistake. It's the document's only official do-over, a rare acknowledgement that sometimes even a supermajority of the country can be wrong. Prohibition lasted 13 years. Its repeal took less than a year once the political will materialized. The 18th Amendment is a cautionary tale. The Constitution is powerful, but it's not infallible. Even the supreme law of the land can screw up. 47. Judicial review isn't in the Constitution. The Supreme Court's power to declare laws unconstitutional, judicial review, is not written anywhere in the Constitution. Article 3 establishes the court but says nothing about striking down legislation. The court gave itself this power in Marbury v. Madison in 1803, when Chief Justice John Marshall ruled that a law conflicted with the Constitution and was therefore void. Congress never voted to approve judicial review. The Constitution never granted it. Marshall just asserted it, argued brilliantly, and made it stick. It's been the foundation of constitutional law ever since. The Supreme Court's authority to be the final word on what the Constitution means exists because the court said so in a single case over 200 years ago. No amendment formalized it. No ratification confirmed it. It's the ultimate power move. The court declared itself the ultimate authority on constitutional meaning, and everyone went along with it. Judicial review is constitutional law's most important doctrine, and it's not actually in the Constitution. 48. The natural-born citizen mystery. The Constitution requires the president to be a natural-born citizen, but it never defines what that means. Does it mean born on U.S. soil? Born to U.S. citizen parents? Born a citizen by any legal means? The debate has raged for centuries. John McCain was born in the Panama Canal Zone. Was he eligible? Barack Obama's father wasn't a U.S. citizen. Does that matter? Ted Cruz was born in Canada to an American mother. Does birthplace override parentage? Constitutional scholars genuinely disagree. Some say natural born means born a citizen without needing naturalization. Others argue it requires birth on U.S. soil. There's never been a definitive Supreme Court ruling because no ineligible candidate has won and forced the issue. So the presidency has a citizenship requirement that nobody can fully explain. It's a constitutional term of art that's never been defined, waiting for a lawsuit that will probably spark a constitutional crisis when it finally arrives. 49. The Constitution was almost a monarchy. This sounds absurd, but it's true. Several delegates at the Constitutional Convention seriously proposed making the president a king in all but name. Alexander Hamilton wanted presidents and senators to serve for life during good behavior, essentially creating an elected monarchy with hereditary-ish senators. He argued that only lifetime appointments could ensure independence from public passions and political corruption. Other delegates floated similar ideas: executive terms of 20 years, presidents chosen by Congress with no public involvement, even genuine hereditary succession. These weren't fringe proposals. They were debated seriously by respected founders who genuinely believed democracy was too unstable to survive without monarchical stability. The ideas were ultimately rejected, but they had enough support to warrant formal discussion. America came closer to having a king than most people realize. The founders designed a republic, but some of them really wanted a crown. Fortunately, they were outvoted, but not by much. 50. Constitutional Convention delegates were young. The image of the Constitutional Convention as a gathering of wise, elderly statesmen is mostly myth. The average age of delegates was 42. Jonathan Dayton of New Jersey was 26, younger than many law school graduates today. Alexander Hamilton was 30. James Madison was 36. Gouverneur Morris was 35. These were relatively young men, many still establishing their careers, shaping the entire future of a nation. Yes, Benjamin Franklin was 81, but he was the exception. Most delegates were middle aged or younger, energetic and ambitious, arguing about governmental structure with the confidence of people who thought they could solve centuries old political problems in a single summer. They weren't ancient sages dispensing wisdom from on high. They were young lawyers, merchants, and landowners winging it in the Philadelphia heat. The founding generation gets mythologized as elder statesmen, but many were just talented people in their 30s and 40s taking a massive gamble on an untested system. Youth and inexperience aren't always weaknesses. Halfway through now. 50 facts about the document that runs America, and we're just getting started on the strange parts. Your pillow is probably feeling pretty good right about now. Let's keep going. 51. The Slave Trade Compromise. The Constitution didn't just protect slavery, it protected the slave trade for 20 years. Article 1, Section 9 banned Congress from outlawing the importation of enslaved people until 1808. Southern states demanded this protection as a condition of ratification, and Northern delegates agreed. It was a 20-year grace period for one of humanity's greatest horrors. The compromise was specific and deliberate. Not a day before 1808 could Congress act. And they did act on January 1st, 1808. The earliest possible date, Congress banned the international slave trade, but the domestic trade continued, and slavery itself remained legal for another 57 years. The Constitution guaranteed 2 decades of continued human trafficking in exchange for political unity. It's one of the document's darkest compromises, a cold calculation that buying time for the slave trade was worth the price of holding the country together. Some prices are too high. The founders paid it anyway. 52. No requirement for a cabinet. The Constitution never mentions a presidential cabinet. Article 2 allows the president to request written opinions from department heads, but it doesn't mandate any departments or advisors. George Washington created the cabinet on his own initiative, appointing a Secretary of State, Secretary of Treasury, Secretary of War, and Attorney General. Every president since has maintained a cabinet, but it's entirely tradition, not constitutional law. Congress creates the departments through legislation. The president appoints the secretaries, but none of it is required by the Constitution. A president could theoretically govern alone, with no advisors, no departments, no cabinet meetings. It would be insane and dysfunctional, but it wouldn't be unconstitutional. The entire executive branch bureaucracy, millions of employees, dozens of agencies, hundreds of billions in budget, rests on custom and statute, not constitutional mandate. Washington invented the cabinet because he needed help. Everyone after him kept it because it worked. But the Constitution never asked for it. 53. The originals are fading. The original Constitution, displayed in the National Archives, is dying. Slowly, invisibly, but inevitably. The iron gall ink used in 1787 is acidic. It eats through parchment over centuries like slow rust, made from oak galls and iron sulfate. It was the standard ink of the era. Prized for its permanence, it's now consuming the very document it was meant to preserve. Light, humidity, and time have all taken their toll. By the mid-20th century, the document was deteriorating rapidly. In 1952, the National Archives sealed it in a helium-filled titanium and glass case with UV-filtered glass to slow the decay. Even so, much of the text is now barely visible to the naked eye. The signatures are fading. Some words have disappeared entirely. High-resolution imaging has captured what's left, but the physical document is slowly disintegrating despite our best preservation efforts. In a few more centuries, it might be completely illegible, just a blank sheet of ancient parchment in a sealed case. The words will survive in copies, but the original will be gone. History preserved in pixels, lost in reality. 54. Women were left out deliberately when the Constitution was written. Women were entirely excluded from political participation. They couldn't vote, hold office, serve on juries, or participate in ratification conventions. This wasn't an oversight, it was deliberate. Abigail Adams famously wrote to her husband John in 1776, "Remember the ladies and be more generous and favorable to them than your ancestors." John laughed it off, replying that men wouldn't give up their power. He was right. Women didn't gain constitutional voting rights until the 19th Amendment in 1920, 131 years after the Constitution was ratified. For over a century, we the people meant men. The founders spoke endlessly about equality, natural rights, and popular sovereignty while systematically excluding half the population. It wasn't ignorance, it was choice. Women fought for constitutional recognition for generations before finally winning it. The Constitution's promises were always universal in language and selective in application. Eventually, the language won. 55. The Constitution allows titles of nobility to be banned. Article 1, Section 9 prohibits the U.S. government from granting titles of nobility. No dukes, earls, or barons in America. It was a clean break from European aristocracy. But it gets weirder. In 1810, Congress proposed a constitutional amendment that would strip citizenship from any American who accepted a title of nobility from a foreign government without congressional consent. The Titles of Nobility Amendment was sent to the states and came within one state of ratification before being forgotten. Some conspiracy theorists claim it was actually ratified and then hidden, but historians agree it fell short. The amendment would have meant that if a king knighted you, you'd lose your citizenship unless Congress approved it. It was anti-aristocracy taken to an extreme, not just banning American titles, but punishing Americans who accepted foreign ones. The amendment failed, but the impulse was real. The founders were so allergic to nobility that they nearly banned Americans from receiving foreign honors. Democracy doesn't do crowns. 56. The Emoluments Clause. Article 1 contains the Emoluments Clause, which prohibits federal officials from accepting gifts, payments, or titles from foreign governments without congressional consent. The idea was to prevent foreign influence and corruption. For over 200 years, it was virtually ignored. Constitutional curiosity with little practical impact. Then it became intensely controversial in recent decades when questions arose about presidents with international business interests. The clause doesn't define emolument. Does it mean direct payments, or does it include profits from business transactions? Does staying at a president's hotel count? What about book royalties or appearance fees? Constitutional scholars disagree. Some say any benefit from a foreign government counts. Others argue it only covers official gifts and titles. The Emoluments Clause sat dormant for centuries, vague and unlitigated. Now it's the center of major constitutional debates. Turns out old clauses don't die. They just wait for the right controversy to become relevant again. 57. The president can pardon almost anything. The presidential pardon power in Article 2 is stunningly broad. The president can pardon anyone for any federal crime, before charges, during trial, or after conviction. The only limit, impeachment. A president can't pardon their way out of being impeached, but otherwise the power is nearly absolute. Gerald Ford pardoned Richard Nixon before any charges were filed, preventing prosecution entirely. Presidents have pardoned family members, political allies, and people they've never met. They can commute sentences, or grant clemency, or wipe criminal records clean. There's no appeal, no oversight, and no requirement to justify the decision. Congress can't override it. Courts can't review it. It's one of the most monarchical powers the Constitution grants, a remnant of the royal prerogative to show mercy. The founders included it as a check on overly harsh laws and a way to heal national divisions. In practice, it's occasionally been used for justice and frequently been used for politics. Either way, it's untouchable. 58. No constitutional right to education. The Constitution does not mention education, not once. There is no federal right to schooling, no guarantee of public education, no requirement that states educate their citizens. Education is entirely left to the states under the 10th Amendment. This is unusual. Most modern constitutions explicitly guarantee the right to education, but America's Constitution is silent. States control curriculum, funding, standards, and access. This is why education quality varies wildly across state lines and why there's no constitutional remedy for underfunded schools or unequal resources. The Supreme Court ruled in San Antonio versus Rodriguez in 1973 that education is not a fundamental constitutional right. Advocates have pushed for a constitutional amendment guaranteeing education, but none have come close to passing. The result is a patchwork system where your access to quality education depends almost entirely on where you're born. The Constitution protects your right to free speech, but not your right to learn how to read. That oversight has shaped and limited American education for over 2 centuries. 59. State of the Union was a letter the Constitution requires the president to, from time to time, give to the Congress information of the State of the Union. For most of American history, presidents fulfilled this obligation by sending a written letter to Congress. Thomas Jefferson started the tradition in 1801, considering in-person speeches too monarchical, too much like a king addressing Parliament. For over a century, presidents submitted written reports that were read aloud by clerks, while Congress sat politely bored. Woodrow Wilson broke the tradition in 1913, delivering the State of the Union as a speech before a joint session of Congress. The spectacle stuck. Now it's an annual televised event with applause lines and political theater and millions of viewers. But for 112 years, the State of the Union was paperwork. The Constitution didn't require speech. It required information. Wilson turned a bureaucratic report into political performance art, and we've been watching it ever since. 60. The Constitution doesn't mention the word fair. Fairness is central to American legal culture, but the word fair never appears in the Constitution. Not once. The closest concepts are due process in the 5th and 14th Amendments and equal protection in the 14th. These were both added later, due process in 1791 and equal protection in 1868. The original Constitution contains no guarantee of fairness, equity, or justice, as we understand those terms today. It establishes procedures and structures, but makes no promises about outcomes. Fair is subjective, emotional, and impossible to define legally, which is probably why the founders avoided it. Instead, they wrote about process, fair trials, equal laws, procedural protections. The substance of fairness was left to interpretation. Americans argue endlessly about what's fair, and the Constitution offers no answers, just mechanisms for deciding. It's a procedural document in a country obsessed with substantive justice. The gap between what we want the Constitution to promise and what it actually says has fueled 2 centuries of constitutional conflict. 61. Ratification was razor thin. The Constitution's ratification was far closer than most people realize. Several states approved it by margins of just a few votes. Massachusetts ratified 187 to 168. a 19-vote margin. Virginia ratified 89 to 79, 10 votes. New York ratified 30 to 27, 3 votes. If just 2 delegates in Massachusetts, Virginia, and New York had voted differently, the Constitution would have failed. These were large, influential states. Without them, the new government would have been stillborn. Ratification wasn't a triumphant national consensus. It was a nail-biting, state-by-state fight that nearly collapsed multiple times. Anti-Federalists had legitimate concerns about centralized power, lack of rights protections, and the potential for tyranny. They almost won. The Constitution passed not because it was perfect or universally loved, but because it was barely acceptable to just enough people. The American experiment started with the slimmest possible majority. History remembers it as inevitable. It was anything but. 62. The 3/5 compromise had a twist. Here's the part that confuses people. The 3/5 compromise actually reduced the political power of slave states compared to what they wanted. Southern slaveholders didn't argue that enslaved people were 3/5 human. They wanted them counted as full persons for representation purposes. More counted people meant more congressional seats and more electoral college votes. Northern states wanted enslaved people counted as 0, arguing that if you deny someone all rights and humanity, you shouldn't get political power from owning them. 3/5 was a compromise that limited Southern power, not an endorsement of their humanity being fractional. It's still morally grotesque, counting human beings as political commodities while denying them personhood. But the math worked against slaveholders, not for them. The compromise gave the South more power than it deserved, but less than it demanded. The 3/5 compromise was a cold bargain dressed in warm mathematics. But the founders weren't always so serious. Sometimes they were just strange. 63. Ben Franklin wanted the turkey. Benjamin Franklin never formally proposed the turkey as America's national symbol, but he did write a letter in 1784 criticizing the bald eagle. He called it a bird of bad moral character because eagles steal food from other birds and are generally lazy scavengers. Franklin wrote that the turkey, by contrast, was a much more respectable bird, and withal a true original native of America. He praised the turkey as brave and willing to attack British soldiers who invaded farmyards during the Revolution. It's unclear how serious Franklin was. He had a sarcastic sense of humor and may have been joking. But the letter exists, and it's been quoted ever since as evidence that Franklin wanted the turkey as the national bird. Whether he genuinely preferred turkeys or was just mocking the eagle, we'll never know. Either way, the bald eagle won. And every Thanksgiving, we eat Franklin's preferred symbol while the eagle glares from coins and flags, vindicated. 64. The Constitution doesn't mention separation of church and state. That famous phrase, separation of church and state, appears nowhere in the Constitution. It comes from a letter Thomas Jefferson wrote in 1802 to the Danbury Baptist Association, explaining that the First Amendment built a wall of separation between church and state. The actual constitutional text says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's the Establishment Clause and Free Exercise Clause, which courts have interpreted as requiring separation. But the phrase itself isn't there. This creates endless confusion. Some argue the founders wanted strict separation. Others claim they only meant to prevent a national church, not remove religion from public life. The Supreme Court has cited Jefferson's letter as authoritative, but it's not constitutional text. It's one founder's interpretation in private correspondence. The Constitution prohibits religious establishments and protects religious freedom. How much separation that requires has been debated for 2 centuries. Jefferson's wall stands, but nobody agrees how high it should be. 65. Constitutional amendments can bypass Congress. Article 5 contains a terrifying provision that almost nobody talks about. States can call a constitutional convention if two-thirds of state legislatures agree. 34 states. That's it. Congress has no power to stop it, control it, or limit it. The convention could theoretically rewrite the entire Constitution from scratch. It's never happened, which is probably for the best. Legal scholars warn that a runaway convention could delete the Bill of Rights, eliminate the separation of powers, or create an entirely new government. There are no rules governing what a convention can or can't do. The delegates wouldn't be bound by the original purpose. It's a constitutional reset button with no safety mechanism. Currently, several advocacy groups are pushing for an Article 5 convention to propose a balanced budget amendment. They're about 6 states away from the threshold. Whether a modern convention could be controlled or would spiral into chaos is an open question. The founders included this option as a check on federal power. It's never been tested, and many hope it never will be. 66. The president doesn't have to live in the White House. The Constitution says nothing about where the president must live. The White House is tradition, not requirement. When the original executive mansion was being reconstructed from 1948 to 1952, President Harry Truman lived across the street in Blair House for nearly 4 years. Perfectly constitutional. A president could theoretically live in a hotel, an RV, or their own home and commute to the Oval Office. Congress provides the White House and maintains it, but there's no legal obligation to reside there. Most presidents live there because it's convenient, secure, and comes with a staff. But it's not mandatory. The White House wasn't even finished when John Adams moved in. Abigail Adams hung laundry in the unfinished East Room. Presidents have treated it as everything from a home to a hotel to a burden. But living there is custom, not constitutional command. Though the Secret Service probably prefers they stay put. The Constitution is full of these vague provisions, things it promises without ever defining. 67. The Guarantee Clause, Article 4, Section 4, contains one of the Constitution's vaguest provisions. The federal government shall guarantee to every state in this union a republican form of government. What does that mean? Nobody knows. The Constitution doesn't define republican form of government. Does it mean representative democracy, protection from monarchy, majority rule with minority rights? The Supreme Court has repeatedly called this a political question and refused to rule on it, leaving enforcement to Congress and the president. This clause was used to justify Reconstruction policies after the Civil War, arguing that Southern states needed to be rebuilt with legitimate Republican governments. But beyond that, it's largely dormant. Could a state switch to direct democracy for everything? Could a governor declare themselves dictator? The Guarantee Clause theoretically prevents this, but there's no mechanism for enforcement, and no court willing to define the terms. It's a constitutional promise with no punch, a protection without teeth. The clause guarantees something important. We just don't know exactly what. 68. The Constitutional Convention's missing delegates. When historians picture the Constitutional Convention, they imagine America's greatest minds assembled in one room. The reality was different. 74 delegates were appointed by their states to attend. Only 55 actually showed up. And some of the most important voices in the American founding were absent entirely. Thomas Jefferson was in Paris, serving as minister to France. John Adams was in London, serving as minister to Britain. Samuel Adams, firebrand of the Revolution, wasn't selected by Massachusetts at all. Patrick Henry boycotted on purpose, already suspicious of what the convention was up to. Rhode Island sent nobody. Many delegates who did show up left before the signing. Some from frustration, some from disgust, some just from the heat. The document that governs 330 million Americans was written by a room where many of the most important voices were empty chairs. The Constitution reflects who was there. It also reflects, in subtle and significant ways, who wasn't. 69. The Constitution was almost rejected by George Washington. In the months before the Constitutional Convention, George Washington wasn't sure he should go. He'd retired to Mount Vernon, was dealing with rheumatism and a painful inflammation in his shoulder, and had recently declined an invitation to attend a veterans meeting, fearing he'd look hypocritical if he then showed up in Philadelphia. More than that, he worried about his reputation. He wrote to friends that if the convention failed, if delegates quarreled and went home with nothing, his attendance would make him look naive or vain. He'd spent years building a reputation for sound judgment. He didn't want to risk it on a convention that might collapse. James Madison, Alexander Hamilton, and others spent weeks writing letters urging him to come, arguing that without Washington's presence, the convention would never command enough public trust to succeed. They were right. He came. The convention succeeded, in large part because everyone in the room believed it must, because Washington believed it must. He almost stayed home. American history almost looked very different. 70. The Whiskey Rebellion. The first constitutional test, the Constitution was ratified in 1788. By 1794, it was already being tested with muskets. In western Pennsylvania, farmers who distilled whiskey had been doing so for generations. It was how they traded surplus grain, how they stored value, how they survived. When the new federal government imposed a whiskey tax, they didn't just complain. They tarred and feathered tax collectors. They burned down the home of a tax inspector. They assembled an armed force of 7,000 men and marched toward Pittsburgh. George Washington, now president, responded by mobilizing 13,000 troops, a larger army than he'd commanded in many battles of the Revolution, and personally led them into western Pennsylvania. He was 62 years old, on horseback, riding toward armed rebels. The rebellion collapsed without a major battle. The farmers dispersed, and 2 leaders were convicted of treason before Washington pardoned them. It was the first real test of whether the Constitution's federal authority could actually be enforced by force. The answer was yes, but it took a president personally riding into the field to prove it. 71. The Constitution was almost rewritten during the Civil War. In 1861, 11 Southern states didn't just leave the Union. They sat down and wrote a new constitution. The Confederate Constitution was modeled closely on the original, so closely that entire passages were copied word for word, but where the 2 documents diverged is revealing. The Confederate Constitution explicitly protected slavery, using the word slave and Negro openly, without the euphemisms the founders had used to avoid confronting what they were doing. It limited the Confederate president to a single 6-year term, so no leader could accumulate power the way Lincoln was, in their view, accumulating it. It gave the president a line-item veto, something American presidents had long wanted. It prohibited protective tariffs, which the South believed favored Northern industry at the South's expense. The Confederate Constitution is a mirror image of the American original. The same structure, the same framework, and a precise record of exactly what Southerners thought the founders had gotten wrong. It lasted 4 years. The original is still going. 72. The Takings Clause. The Fifth Amendment says the government can take private property for public use with just compensation. This is the Takings Clause, and it's been stretched far beyond its original meaning. Initially, public use meant things like roads, schools, and military bases, property the government would own and the public would use. But in Kelo versus City of New London in 2005, the Supreme Court ruled that public use includes taking property from one private owner and giving it to another private owner if it promotes economic development. The city took homes through eminent domain and transferred the land to a private developer who promised jobs and tax revenue. The development never happened. The land sat empty for years, but the ruling stood. Public use now means public benefit, which can mean almost anything. The government can take your house, pay you market value, and give the land to a corporation if officials think it'll help the economy. The takings clause was meant to protect property rights. It's become a tool for transferring them. 73. Pocket veto loophole. Here's a constitutional quirk. If the president ignores a bill for 10 days while Congress is in session, it automatically becomes law without a signature. But if Congress adjourns within those 10 days, the bill dies. A pocket veto that can't be overridden. It's a procedural loophole built into Article 1, Section 7. The president doesn't have to veto the bill or explain the decision. The bill just disappears. Congress can't override a pocket veto because there's no formal veto to override. The bill simply fails to become law. Presidents have used pocket vetoes hundreds of times, often for controversial bills they don't want to publicly oppose. It's passive-aggressive governance enshrined in constitutional procedure. The founders included it to prevent Congress from passing bills at the last minute and then leaving town before the president could respond. But it's become a way for presidents to kill legislation without accountability. The pocket veto is constitutional ghosting. Ignore the bill, wait for Congress to leave, and let it die quietly in the pocket. 74. The convention's drinking tab. 2 days before signing the Constitution, the 55 delegates threw a farewell party at City Tavern in Philadelphia. The bar tab, preserved in historical records, is legendary. 54 bottles of Madeira, 60 bottles of claret, 8 bottles of whiskey, 22 bottles of porter, 8 bottles of hard cider, 12 bottles of beer, and 7 large bowls of alcoholic punch for 55 men. That's over 2 bottles of wine per person, plus whiskey, plus beer, plus punch. The bill came to $89.74, a fortune in 1787. They drank enough to float a small ship while celebrating the document that would govern millions. It's a reminder that the founders were human, brilliant, visionary, and apparently capable of absolutely legendary alcohol consumption. They spent months debating the separation of powers and the nature of republicanism, then closed it out with enough booze to knock out a modern fraternity. The Constitution was signed with hangovers. Democracy was born in a tavern. 75. George Mason's refusal. George Mason of Virginia was one of the most influential delegates at the Constitutional Convention. He'd written the Virginia Declaration of Rights, which inspired much of the Bill of Rights. But when it came time to sign the Constitution, Mason refused. He had 2 main objections. The document lacked a Bill of Rights, and it didn't immediately end the slave trade. He stood in that room surrounded by delegates signing and said no. His refusal wasn't symbolic. It was personal. Mason and George Washington had been friends for decades. After Mason refused to sign, Washington never spoke to him again. Their friendship ended over constitutional principle. Mason became one of the Constitution's most vocal opponents, arguing against ratification in Virginia and warning that the new government would become tyrannical. He was partially right. The lack of a Bill of Rights nearly killed ratification, and one was added 3 years later. Mason didn't live to see it. He died in 1792, still convinced the Constitution was flawed. Sometimes refusing to compromise costs everything. Mason paid the price. 75 facts deep. The Constitution is starting to look less like a sacred document and more like a very long to-do list written by people who were making it up as they went. If you're drifting off, that's perfectly fine. The amendments will be here when you wake up. 76. Constitutional Interpretation Wars. In 2008, the Supreme Court faced one of the most consequential cases in its history, District of Columbia versus Heller. A man named Dick Heller, a security guard, wanted to keep a handgun at home in Washington, D.C. The city said no, and the entire case came down to a question that has haunted constitutional law for 2 centuries. Do we read the Constitution as the founders meant it in 1787, or as our generation needs it today? Originalists argued the Second Amendment's phrase, well-regulated militia, tied gun rights to military service. That's what the founders intended, so that's what the law must mean. The other side argued that a living, evolving constitution must speak to modern realities, that a right to self-defense in your own home is obviously what the amendment protects, whatever the founders' precise intent. The court ruled 5-4 in Heller's favor, an originalist victory, but 4 justices dissented. Tout, the war over constitutional meaning isn't settled. It's waged, case by case, in every contested ruling, with no ceasefire in sight. Whose interpretation counts is the question that never gets answered. It's just argued again, louder, the next time. 77. The president can't declare war. Article 1. Section 8 gives Congress the exclusive power to declare war. Only Congress. The president is commander-in-chief, but starting a war requires congressional authorization. That's the theory anyway. In practice, presidents have sent troops into combat hundreds of times without a formal declaration of war. Congress has officially declared war only 5 times in American history. The War of 1812, the Mexican-American War, the Spanish-American War, World War I, and World War II. The last declaration was in 1942. Since then, America has fought in Korea, Vietnam, Iraq, Afghanistan, and dozens of smaller conflicts, all without formal declarations. Instead, Congress passes authorizations for the use of military force, which technically aren't war declarations, but functionally serve the same purpose. The constitutional requirement that Congress declare war has been bypassed through creative language and political acquiescence. Presidents wage war. Congress funds it. Nobody declares it. The Constitution's war powers have been quietly rewritten through practice, leaving the text intact while ignoring its requirements. 78. Letter of Marque. Here's a constitutional power that sounds like pirate fan fiction but is completely real. Article 1, Section 8 gives Congress the authority to issue letters of marque and reprisal. These are essentially licenses for private citizens to attack and seize enemy ships during wartime, government-sanctioned piracy. Privateers would get a letter from Congress authorizing them to raid enemy vessels, keep the loot, and weaken enemy trade. It was common in the 18th and 19th centuries when navies were small and governments needed help disrupting enemy shipping. The U.S. issued letters of marque during the Revolution and the War of 1812. The last one was issued in 1815. Since then, nothing. The power still exists in the Constitution, unused and mostly forgotten. Congress could theoretically issue letters of marque today, authorizing private ships to attack enemy nations. It would be bizarre, possibly illegal under international law, and absolutely constitutional. The Constitution includes a provision for legal piracy, and it's just sitting there, waiting for someone desperate or creative enough to use it. 79. The Constitution was kept in a closet. For the first 100 years of its existence, the Constitution was treated with shocking carelessness. It was stored in various government offices, moved between buildings, sometimes kept in closets or file cabinets. It was exposed to light, humidity, temperature swings, and general neglect. During the War of 1812, it was hastily evacuated from Washington when the British burned the Capitol, stuffed into linen bags, and hauled to safety. For decades, it sat in the State Department, displayed occasionally, mostly ignored. It wasn't placed in proper protective storage until 1924, when it was transferred to the Library of Congress. Even then, preservation was rudimentary. In 1952, it finally received the treatment it deserved, sealed in helium filled cases with UV filtered glass in the National Archives. The Constitution, the foundation of American government, spent a century being stored like old tax records. It survived through luck as much as care. The document that governs millions was kept in a closet. 80. The Full Faith and Credit Clause, Article 4, Section 1 requires every state to give full faith and credit to the public acts, records, and judicial proceedings of other states. This is why a marriage license from Nevada is valid in New York, why a driver's license from Idaho works in Florida, why a divorce decree in California is recognized in Texas. The Full Faith and Credit Clause makes the United States function as a single legal system despite having 50 different state governments. Without it, you'd need a new license, marriage certificate, and legal identity every time you crossed state lines. It sounds simple, but it's been at the center of major constitutional battles, especially around marriage. When some states legalized same sex marriage and others didn't, the question became, does the Full Faith and Credit Clause require all states to recognize those marriages? The Supreme Court eventually ruled in Obergefell versus Hodges that states must license and recognize same sex marriages, rendering the question moot. The clause holds the country together, forcing states to respect each other's legal acts, even when they disagree with them. 81. Amendments almost never expire. Most proposed constitutional amendments have no ratification and deadline. They're just out there, pending forever, waiting for states to ratify them. The 27th Amendment, the Congressional Pay Raise Amendment, was proposed in 1789 and ratified in 1992, 203 years later. It proves that amendments without deadlines can eventually pass if someone keeps pushing. The Equal Rights Amendment, proposed in 1972, was given a deadline of 1979, later extended to 1982. It fell 3 states short. Some scholars argue that congressional deadlines are unconstitutional, that Congress can't legally impose time limits on the ratification process. If true, the ERA could still be ratified today if enough states approved it. Other proposed amendments from the 1790s are technically still pending, though functionally dead. The constitutional amendment process exists outside normal time. Proposals can sit dormant for centuries and suddenly spring to life. Amendments almost never truly die. They just wait. 82. The Recess Appointments Clause, Article 2, Section 2 allows the President to make temporary appointments without Senate confirmation when the Senate is in recess. It was designed for a time when Congress met infrequently and traveled by horse. If a cabinet position opened while the Senate was home for months, the President needed a way to fill it. Modern presidents have used recess appointments to bypass Senate opposition, installing controversial nominees when Congress takes breaks. The Senate fought back by holding pro forma sessions, meetings where a single senator gavels in, conducts no business, and gavels out in under a minute. These sessions technically keep the Senate in session, preventing recess appointments. It's constitutional theater. The Senate pretends to meet so the president can't make appointments, and everyone pretends this makes sense. The Supreme Court ruled in NLRB versus Noel Canning in 2014 that pro forma sessions count as being in session, effectively neutering the recess appointment power. A constitutional provision designed for horse and buggy logistics has been gamed into irrelevance by procedural gimmicks. The Recess Appointments Clause still exists. It just doesn't work anymore. 83. Roger Sherman signed all 4. Roger Sherman of Connecticut is the only person who signed all 4 major founding documents: the Articles of Association in 1774, the Declaration of Independence in 1776, the Articles of Confederation in 1781, and the Constitution in 1787. He was present at every pivotal moment, putting his name on every document that shaped American independence and governance. Sherman wasn't flashy like Hamilton or eloquent like Madison. He was a self taught lawyer, former shoemaker, and practical problem solver who showed up, did the work, and signed his name. He proposed the Great Compromise that saved the Constitutional Convention, creating the bicameral legislature that balanced large and small states. He spoke more than 100 times during convention debates, always focused on practical solutions rather than theoretical arguments. Sherman didn't seek fame or historical glory. He just kept showing up and fixing problems. By the time he died in 1793, he'd signed more founding documents than anyone in American history. Persistence beats brilliance sometimes. 84. The Constitution says nothing about congressional committees. Congressional committees, armed services, judiciary, intelligence, appropriations, are not mentioned anywhere in the Constitution. Not once. Article 1 establishes Congress and grants it legislative powers. But it says nothing about how Congress should organize itself internally. Committees are entirely congressional inventions, created through rules and tradition. The first committees were temporary, formed to handle specific bills and then dissolved. Permanent standing committees emerged in the early 1800s as Congress realized it needed specialized groups to handle complex legislation. Now committees are where the real work happens, drafting bills, holding hearings, conducting oversight. Most legislation dies in committee without ever reaching a floor vote. Committee chairs wield enormous power, controlling what gets considered and what gets buried. The entire committee system, the backbone of how Congress functions, exists outside the Constitution. It's a structural innovation built on practice and not text. The founders gave Congress the power to make laws, but left the process entirely up to Congress to figure out. 85. The Constitutional Convention was technically illegal. Here's a dirty little secret. The Constitutional Convention exceeded its legal authority from day one. The convention was called to revise the Articles of Confederation, to propose amendments and improvements to the existing government. Instead, the delegates threw out the articles entirely and wrote a completely new constitution, creating a completely new government. They weren't authorized to do that. They did it anyway. Then they made it worse. The Articles of Confederation required unanimous consent from all 13 states to amend. The new Constitution required only 9 states to ratify, completely bypassing the existing legal framework. The founders essentially staged a peaceful constitutional coup, ignoring the rules they were supposed to follow and creating new rules that suited their purposes. It worked because the Articles of Confederation government was too weak to stop them and because enough people wanted change. But legally, the Constitutional Convention was unauthorized. The document it produced was illegitimate under existing law, and the ratification process violated the amendment procedures. The Constitution was born from creative rule-breaking. History called it a revolution. Technically, it was also a crime. 86. Free speech wasn't always free. The First Amendment was ratified in 1791, guaranteeing freedom of speech. 7 years later, Congress passed the Sedition Act of 1798, making it a crime to publish false, scandalous, and malicious writing against the government. Criticize President John Adams or Congress. That's a federal crime. Several newspaper editors were arrested, tried, and jailed for printing negative opinions about the administration. The Sedition Act expired in 1801, but the damage was done. The generation that wrote the First Amendment also passed a law criminalizing speech they didn't like. It's a reminder that constitutional rights aren't self-enforcing. They require people in power to respect them, and sometimes those people don't. The Sedition Act was never ruled unconstitutional. It expired before the Supreme Court could review it, but it exposed the gap between constitutional text and constitutional practice. Free speech is only as free as the government allows it to be. The First Amendment promises protection. History shows the promise isn't always kept. 87. The guarantee of jury trials. The Sixth and Seventh Amendments guarantee the right to trial by jury in criminal and civil cases. It's one of the Constitution's most celebrated protections, the idea that ordinary citizens, not government officials, decide guilt or innocence. In practice, about 97% of federal criminal cases never see a jury. They're resolved through plea bargaining, where defendants plead guilty in exchange for reduced charges or lighter sentences. Prosecutors have enormous leverage. They can threaten harsher penalties if defendants insist on trial, making plea deals feel less like choices and more like coercion. The jury trial guarantee still exists in theory. In practice, it's been replaced by a system of negotiated guilty pleas that happens in prosecutors' offices, not courtrooms. The Supreme Court has allowed this because plea bargaining is considered efficient and voluntary. But the result is that the constitutional right to a jury trial has become a right most defendants waive under pressure. The guarantee is still there. The reality is something else entirely. 88. The vice president's tie-breaking power is massive. The vice president's constitutional role is mostly ceremonial, but the tie-breaking power in the Senate is real and occasionally decisive. Article 1, Section 3 gives the VP the power to vote in the Senate only when the chamber is evenly divided. Throughout history, vice presidents have cast over 290 tie-breaking votes. John Adams holds the record with 29. These votes have decided wars, budgets, tax policy, and the fate of entire federal agencies. A single vote from the VP can override the will of 49 senators and reshape national policy. It doesn't happen often. Most legislation doesn't come down to a tie. But when it does, the vice president becomes the most powerful person in the building. Mike Pence cast 13 tie-breaking votes. Kamala Harris cast more than 30, the most in decades. The VP's tie-breaking power is a constitutional quirk that occasionally becomes a constitutional weapon. Most of the time, vice presidents sit silently, presiding over Senate sessions. Sometimes they decide everything with one vote. 89. The Constitution doesn't mention the Attorney General. The Attorney General, the nation's top law enforcement official and head of the Department of Justice, is not mentioned anywhere in the Constitution. Article 2 allows the president to appoint officers and seek opinions from department heads, but it doesn't specify which departments or officers should exist. Congress created the position of Attorney General through the Judiciary Act of 1789, and the Department of Justice wasn't established until 1870. For nearly a century, the Attorney General existed without a department, functioning as the president's personal lawyer. The entire modern Justice Department, with its tens of thousands of employees, FBI, federal prosecutors, and law enforcement agencies, rests on congressional legislation, not constitutional mandate. The president doesn't have to have an attorney general. Congress doesn't have to fund the Justice Department. It's all statutory, not constitutional. The nation's chief law enforcement structure exists because Congress said so, not because the Constitution required it. Constitutional silence leaves room for congressional creativity, and sometimes that creativity builds entire branches of government. 90. The president can't be arrested while in office. There's no constitutional provision stating that a sitting president can't be indicted or arrested. It's not in Article 2. It's not in any amendment. It's a Department of Justice. Legal opinion issued in 1973 during the Watergate scandal. The DOJ's Office of Legal Counsel concluded that prosecuting a sitting president would unconstitutionally interfere with executive functions. The opinion has been reaffirmed by subsequent administrations, but it's not law. It's policy. No court has ruled on whether a sitting president can face criminal charges. It's an untested constitutional question. Some scholars argue the president isn't above the law and can be prosecuted like anyone else. Others argue that impeachment is the only remedy while in office, and criminal prosecution must wait until after leaving. The question of whether the most powerful person in America is above the law has been answered not by the Constitution, not by the Supreme Court, but by a memo. And memos can be shredded. We're in the final stretch. Just a handful of facts left. If you've made it this far, you now know more about the Constitution than most law school graduates. If you fell asleep somewhere around the Commerce Clause, I don't blame you. Sweet dreams either way. 91. The Exceptions Clause. Article 3, Section 2 contains a little-known provision. Congress can strip the Supreme Court of jurisdiction over specific types of cases. It's called the Exceptions Clause, and it gives Congress the power to prevent the court from ruling on controversial issues. Congress has used this power sparingly but effectively. After the Civil War, Congress removed the court's jurisdiction over habeas corpus cases to prevent it from ruling on Reconstruction policies. More recently, proposals have been floated to strip the court's jurisdiction over abortion, gun rights, or same-sex marriage. The Exceptions Clause is a nuclear option, a way for Congress to overrule the Supreme Court by preventing it from having a say. It's controversial because it undermines judicial independence and could politicize jurisdiction, but it's clearly constitutional. Article 3 gives Congress control over the court's appellate jurisdiction, and Congress can use that control to limit or expand what cases the court hears. The Supreme Court's power is only as broad as Congress allows. The Exceptions Clause is a reminder that the court isn't truly supreme. 92. Constitutional amendments can have an expiration date. Congress can attach deadlines to proposed constitutional amendments, giving states a limited window to ratify. The 18th Amendment, Prohibition, had no deadline and was ratified quickly. The Equal Rights Amendment, proposed in 1972, had a 10-year deadline, later extended to 1982. It fell 3 states short and expired. Whether Congress can constitutionally impose deadlines is debated. Some scholars argue that Article 5's amendment process includes no provision for time limits, making congressional deadlines unconstitutional. Others argue Congress has broad power to set reasonable conditions on ratification. The Supreme Court has never definitively ruled on this. If deadlines are unconstitutional, then expired amendments like the ERA could theoretically still be ratified today. If deadlines are valid, then amendments die when time runs out. The uncertainty creates legal limbo. Proposed amendments sit in constitutional purgatory, neither fully dead nor alive. Some amendments have been pending for over 2 centuries. Others expired decades ago. Whether they can be revived is an open constitutional question with no clear answer. 93. The Constitution technically allows slavery as punishment. The 13th Amendment, ratified in 1865, abolished slavery and involuntary servitude throughout the United States, except it didn't. The text contains a crucial exception. Except as a punishment for crime whereof the party shall have been duly convicted. Slavery is banned unless you've been convicted of a crime. Then it's constitutionally permitted. This exception is the legal foundation for prison labor programs that pay inmates pennies per hour for work that benefits private companies and government operations. Incarcerated people manufacture goods, fight wildfires, and perform services while earning wages far below minimum wage, sometimes nothing at all. The 13th Amendment's exception has been criticized as perpetuating slavery through the criminal justice system, particularly given racial disparities in incarceration. Some states and advocacy groups are pushing for amendments to remove the exception and ban all forms of involuntary servitude without qualification. But as written, the Constitution that ended slavery also preserved it for the convicted. The amendment that freed millions left a door open for a different kind of bondage. 94. The census determines everything. Article 1, Section 2 requires a census every 10 years to count the population. That count determines everything. How many representatives each state gets in Congress, how many electoral college votes each state receives, cuts, and how over $1.5 trillion in federal funding gets distributed. Undercount your state's population, and you lose political power and money for a decade. The census isn't just statistics, it's the foundation of representative democracy and fiscal policy. States and cities fight viciously over census methodology, citizenship questions, and sampling techniques because the stakes are enormous. One miscounted district can mean losing a congressional seat. One undercounted city can mean losing millions in federal grants. The census is also deeply political. Who gets counted, how they're counted, and what questions are asked have sparked constitutional battles for decades. The founders required a census to ensure fair representation. They couldn't have imagined it would determine the distribution of trillions of dollars and reshape political power for years at a time. The census counts people, but it really counts power. 95. The original document has been to Fort Knox during World War II as Nazi Germany conquered Europe and the threat of invasion loomed. The United States government decided to evacuate its most important documents. In December 1941, just days after Pearl Harbor, the Constitution, the Declaration of Independence, and the Gettysburg Address were secretly transported from Washington, D.C. to Fort Knox, Kentucky, the heavily fortified military base famous for storing the nation's gold reserves. They were packed in specially designed containers, loaded onto trains under armed guard, and locked in the vault alongside America's gold bullion. They remained there until 1944, when the threat subsided and they were returned to Washington. For nearly 3 years, the Constitution was stored in a vault in Kentucky, protected by the U.S. Army and tons of gold. It's a strange historical footnote. The document that founded the nation spent the war hiding in a military fortress, waiting to see if the country it created would survive. The Constitution came home when the war ended. Democracy improbably endured. 96. Constitutional law is mostly case law. The actual text of the Constitution contains 4,543 words. The body of Supreme Court opinions interpreting those words exceeds 500,000 pages. Most of what we call constitutional law was written by judges, not the founders. The Constitution says Congress can regulate interstate commerce. Judges decided that means the federal government can regulate wheat you grow in your backyard for personal use. The Constitution prohibits unreasonable searches. Judges decided what unreasonable means for wiretaps, drug-sniffing dogs, and GPS trackers. The First Amendment protects free speech. Judges decided whether that includes flag burning, campaign donations, and internet pornography. Constitutional law is a vast structure of judicial interpretation built on a slim foundation of original text. The Constitution provides the framework. Centuries of court rulings fill in the details, often creating rules the founders never imagined. When lawyers argue constitutional law, they cite cases, not the Constitution itself. The document matters, but the interpretations matter more. Constitutional law lives in the volumes of case law, not the 4 pages of parchment. 97. Slavery was debated for 6 weeks. The Constitutional Convention spent more time arguing about slavery than any other single issue. 6 full weeks of debate, compromise, anger, and moral evasion. Northern delegates wanted to ban the slave trade immediately. Southern delegates threatened to walk out if slavery was even criticized. The compromises that emerged, the Three-Fifths Clause, the Fugitive Slave Clause, the 20-year protection for the slave trade, held the fragile Union together for 73 years. Then the Civil War tore it apart anyway. The founders knew slavery was the fault line that could destroy the country. They debated it exhaustively, crafted careful language, and ultimately chose union over principle. They kicked the problem to future generations, hoping time would solve what they couldn't. It didn't. It took 600,000 deaths and a constitutional amendment to resolve what the founders left unresolved in Philadelphia. The 6 weeks of debate bought decades of peace and postponed a reckoning that eventually came anyway. Compromise delayed the inevitable. It didn't prevent it. 98. No term limits for Congress. The 22nd Amendment limits presidents to 2 terms. But senators and representatives can serve as long as voters keep electing them. There are no constitutional term limits on Congress. The founders debated the question in 1787 and ultimately decided that periodic elections were a sufficient check. If a congressman was truly unfit, voters could remove them. What the founders didn't anticipate was the structural advantage of incumbency. Name recognition, fundraising networks, committee seniority, and the power to draw their own district lines. In the modern era, incumbents win re-election at rates above 90%. Some members of Congress have served for 40 or 50 years, accumulating influence that no newcomer can touch. The tension between democratic accountability and institutional knowledge was never resolved in the Constitution. It was just left to voters who, by and large, keep re-electing the same people while telling pollsters they want change. Term limits have been proposed dozens of times. None have passed. The founders trusted elections to police the legislature. Elections have largely declined the job. 99. It was designed to be imperfect. On the final day of the Constitutional Convention, Benjamin Franklin gave a brief speech before signing. He was 81, exhausted, and clear-eyed about what they'd created. He said he agreed to the Constitution with all its faults because he thought a general government was necessary. He didn't claim perfection. He acknowledged flaws. He signed anyway because something imperfect was better than nothing at all. The founders knew the Constitution was incomplete, contradictory, and compromised. They protected slavery while proclaiming liberty. They created a republic while distrusting democracy. They built checks and balances that sometimes prevent progress and sometimes prevent tyranny. And they included the amendment process specifically because they knew future generations would need to fix their mistakes. The Constitution wasn't meant to be perfect. It was meant to be a starting point, a framework adaptable enough to survive centuries of change. Franklin's wisdom wasn't in celebrating the document. It was in recognizing that imperfect governance beats perfect paralysis. The Constitution's greatest strength isn't what it says. It's that it can be changed. The Constitution began in secrecy, written by brilliant but flawed people who knew they were creating something imperfect. They protected slavery while proclaiming liberty. They created democracy while distrusting voters. They built a government designed to move slowly, change reluctantly, and survive anyway. It's been amended 27 times. It's survived a civil war, 2 world wars, and countless crises. It's been stretched, interpreted, ignored, and revered. And after 237 years, it's still here, fading, imperfect, and somehow still working. So tonight, as you drift off to sleep, remember, the foundation of American democracy was written by men who got drunk on Madeira, argued for 6 weeks about slavery, and then admitted they had no idea if any of it would work. They were right to worry, but somehow we're still here. Sleep well.